Good morning, everybody. Jai Maharashtra. We're talking about open access in Maharashtra. We're talking about distribution open access in Maharashtra. The regulations talk about it and has been abbreviated as DOA regulations. There is a joke going on among some of the lawyers. This is death of open access regulation. And there are various aspects around it and which I'm going to briefly touch upon, and I think Harry laid the foundation. Thanks to IPPA, thanks to everybody here. With permission from Dr. Dev, I would like to state that as a lawyer, I have a very cynical view of the things, and therefore I say this is death of open access today, and not really challenges in open access. We talked about the statement of objects and reasons for Electricity Act 2003. Harry virtually read the main object touching upon new concepts in 2003 being introduced through a legislation. And one of the new concepts that was thought about in 2003 was open access. The statement of objects and reasons categorically articulate that. When we look at the MERC DOA regulations, it still talks of open access being a new concept. Over the period of 13 years, the new concept of open access continues to be new concept of open access insofar as legislations are concerned, insofar as laws are concerned. Now, on one hand, we started off with the concept of open access even prior to 2003 because I think the old acts and the schemes were not working out. New legislation came in. We said it made economic sense to bring in open access through a legislative mandate. Talked about competitiveness, talked about opening of the entire sector, talked about reforms around 2003. And we again said there is an economic sense in ensuring that the open access is promoted through a legislative mandate. The promotion of open access had a backing from even the World Bank reports specifically made applicable with studies from Maharashtra, Gujarat, and some few other states of India prior to 2003 to say that this is one of the solutions where the stranded capacity that is lying today would be made available, and a willing buyer and a willing seller can probably enter into a contract, and therefore the concept of free flow of electrons through a contractual arrangement can happen. That was the fundamental, that you have a willing buyer and you have a willing seller. If you have willing buyer and a willing seller and the capacities for transmission of electron is available, encourage the open access so that the standard capacities can be utilized. Overall impact on tariff could be favorable. The tariffs may see certain amount of reduction there. And therefore the legislation suggested open access. It realized that this can't be done overnight through a legislative change. So it said that prospectively, let the state commissions come out with the regulations relating to open access. And that's primarily flowing from section 42, 42.2 with a focus on distribution open accesses. Clearly, progressively, what happened in the distribution open access regulations is for everybody to see. We have in probably the most progressive state in country, Maharashtra, the open access regulation coming in 2016. It made economic sense. It made commercial sense. It talked about free flow of electron, a willing buyer and a willing seller wanting to enter into a contract for sale and purchase of electricity through open access mechanism. While the legislative mandate is on one side, let's look at what every other stakeholder in the ecosystem did. One, it became difficult to bring out these regulations at the state level or the state regulatory commissions level. Unbundling of the kind of electricity boards resulted into discoms and the manner in which discoms got promoted as virtually the state companies. The objective again, I think I just go back to the old Electricity Act to say that old Electricity Act also mandated the state electricity boards to work efficiently, economically, and on sound business principles, and Supreme Court interpreted this to mean that while you have public interest at large as a focus area, you need to ensure that you are operating efficiently, economically, and on sound business principles. It's been interpreted under the old Electricity Act, Supply Act. Come 2003, everybody thought that, wow, what a great thing to happen. Everything is getting unbundled. We will have companies with a focus so that the unbundled electricity board companies, whether it is Genco, Transco, Discom, will actually function in a far better manner and would not have complete control of the state government. They would not be extended arm of the state government or part of the state government, although these are state companies. On the other hand, the legislation or the law envisaged that there will be regulatory commission which independently regulates the entire space at the state level and as well as at the central level. With independent regulators, unbundling of state electricity boards and forming of this company, the objective seemed to be moving towards encouraging open access, encouraging willing sale and purchase of electricity. However, all the stakeholders again came together to see that the regulations don't happen. The open access regulations became difficult. Initially, I remember discussing with Harry in terms of saying that if you make an application for open access, what do you do if the Transco comes back and say, I have no capacity and I'm denying you open access? Can we really go to the courts and ask the courts to intervene to enforce and look at whether the reasons for non-grant of open access are cogent enough to survive the scrutiny of the courts? And I think there have been a couple of cases, not in Maharashtra, but other places where I think this push and pull happened, where the courts proactively looked at the issue and tried to put some pressure back to say that if the objective of the Electricity Act 2003 is that of promoting open access, you need to have cogent reasons for denying open access. And I think that's one factor, and that's one area where the courts tried to push across. Various policies, various provisions under the Act, we were trying to give meaning to, trying to interpret in favor of a free exchange or free transaction, commercial transactions of sale and purchase of electricity. But the entire ecosystem probably worked against creating a conducive atmosphere on the open access, and that continues. We have electricity duty, we have cross-subsidy surcharge, we have various elements that are virtually discouraging open access today. And I can kind of go on narrating individual actions at micro level of various discoms, including the state discom, where the issue that comes into the mind is to say that, sorry, if you are, just to give you one example, we have the Marathwada and Vidarbha subsidy issue. One of the conditions why any industry in Marathwada and Vidarbha will get the subsidy would be they have to procure 100% power only from discom. Then only they will be entitled to the subsidy. So obviously, Maharashtra for open access has suddenly shrunk. Marathwada and Vidarbha region, nobody would go for open access, because if they want the subsidy, which is working out to, at some point in time, and Deshpande Saab, correct me if I'm wrong, almost about 3 rupees to 3 rupees 70 paisa. See, the total subsidy in some cases in Marathwada and Vidarbha works out to almost about 3 rupees to 3 rupees 75 paisa. So, which industry in Marathwada and Vidarbha is likely to go in for open access? Answer is no one. So suddenly for open access, the Maharashtra is shrunk to rest of Maharashtra. What's happening in rest of Maharashtra? Let's look at. I mean, Harry touched upon one form that needs to be filed where all the information will have to be given. The open access regulations 2016 contemplate MSCDCL as a nodal agency. As I said earlier, MSCDCL probably unbundled state electricity board. Focus ought to have been the commercial entity. Focus ought to have been through the restructuring, create healthy discoms. So it has a business objective there, which is to ensure that the discom operates on business principles. Discom itself is now the nodal agency. And I think in the electricity sector, right since probably 2001, we've been fighting to say that look at the conflict of interests all across. We have instances where there is a clear conflict of interest. There were clear issues of what we lawyers call as quo warranto. In one case, I think a person who is supposed to regulate elects himself to be a regulator, and the vice versa, and the things go on. The conflict of interest is never looked at. From that perspective, when the distribution open access creates in DISCOM a nodal agency, there is bound to be inherent conflict of interest. Because on one hand, MSCDCL's focus is to make sure that it is operating on sound business principles and promoting its business objectives. On the other hand, as a nodal officer under the regulation, it has powers which are akin or identical that of a regulator to extent it can be argued that MSCDCL is a statutory regulator insofar as open access issues are concerned. The inherent conflict of interest gives nodal agency and a distribution licensee as the same person and leads to quo warranto kind of a situation. A regulatory role of a nodal agency and its business objective cannot be clubbed together. Therefore, the nodal agency is going to overreach the regulation. When the regulation, and I think these regulations are really micro level regulation, they tell you what information is required, what forms have to be filed. I mean, in India, I think we all have these micro level legislations which tell you exactly what you are supposed to do. And if the nodal agency is asking information beyond that, for what? Obviously, the roles get mingled and the allegations would be that the MSCDCL is going to use that information to promote its own business. The second aspect which is coming up, as I briefly touched upon on the electricity duty, I briefly touched upon on the subsidy, is that when I think government was looking at how do you put this promise given to Vidarbha and Marathwada, how do you put that and implement it together? Incidentally, I am from Marathwada and I have nothing against either of the regions. How do you put that promise into place? I think interdepartmental committee was set up, and the recommendations of the committee, and I'm just going to read out one sentence out of it. It says that its incentives are fine. We'll focus, we'll kind of objectively look at it. It says the committee, this is interdivisional committee, which was to focus on Marathwada and Vidarbha, subsidies to Marathwada and Vidarbha. It said, moreover, the committee firmly believes that the incentives will work only in the short term. Hence, as part of medium and long-term measures, the committee has also worked out some drastic structural reforms in the operations of DISCOM. Nobody has talked about it. Just to kind of recap the history, after this divisional committee report, its recommendations were not in whole accepted. There was some other committees of secretaries formed thereafter. I think the recommendations went up to the minister. Minister changed those recommendations. I mean, that's part of the history. But what happened eventually is that about 1,100 crore every year subsidy was allocated to Marathwada and Vidarbha. And you will find this in budget speech of the chief minister and on the floor of the house, which talked about 1,100 crore subsidy being given for Marathwada and Vidarbha. Objections were raised as to where is this money going to come from. So the recorded position of the government has been that this is going to come almost to the extent of about 800 crores odd by levying or increasing electricity duty on open access consumers and captive consumers. Now, if you look at this from this perspective, that the objective of the Electricity Act, which again I think Harry touched upon it, to say that we need to look at how do you reduce the cross subsidy over the period of time, how do you kind of make sure that the electricity duty enhancement doesn't go back to the subsidy or get that linkages there. That was the objective under the tariff policy. Now, incidentally, as a lawyer, it's very interesting for me to analyze this. The tariff policy, which is statutory tariff policy under a statute, has been interpreted by Supreme Court to mean these are merely guidelines. So they're not legally enforceable. Whereas if you look at EXIM policy under the export-import laws, it's more rigorously implemented, though it's called policy. It's a legislative policy under a statute, which is different from an administrative policy outside the enactment. Notwithstanding, and we'll have to respect the Supreme Court judgment for that, but notwithstanding that, the objective seems to be, since the tariff policy is not legally enforceable, I think the state governments are willy-nilly giving a go-by to the intent of the tariff policies. When it comes to electricity duty and the Duty Act of 2016, I think this is a tax on consumption. And under the guise of tax on consumption, what's happening is that they're saying, tell us where the power is getting generated. Is it captive? We're going to levy a duty in a particular manner. Is it open access? We're going to levy a duty in a particular manner. Under the guise of consumption, you're looking at levying duty or levying tax on the generation part of it. However, I think the courts again have taken a view, and Andhra High Court, in the case of Rane Engineering in May of 2016, took a view that there is no conflict between the Electricity Act and levying of the duty based on whether it is captive consumer or whether it is open access. It didn't say it clearly in terms of open access, but when it came to captive consumption, they clearly said that no, this is in the field of state government under the constitution, and therefore state is fully entitled to levy tax, although under the guise of consumption, the generation is being looked at. The only obiter there is that they said it would have been better had the state government taken the regulator into confidence while looking at this issue. And I think what may have happened, although they didn't kind of uphold the challenge or constitutional virus of the levy of the duty, the court said that it would have been better if the regulatory commissions would have been taken into confidence in this. What would have happened, and if in an ideal situation, if the regulator is independent, and regulator is today custodian of the tariff policy, regulator would have said that the issue of subsidy and duty cannot be commingled in the manner in which we are doing it. To an extent, on the record, as I mentioned earlier, government has said that the deficit for subsidy which will be granted to MSEDCL will come from levy of electricity duty on open access consumers and captive consumers. That's insofar as the aspect of subsidy and electricity duty is concerned. So, as we said, the discoms, sorry, yeah, I think, yeah, on the retrospective levy of the duty, uh, just go back to Vodafone, just go back to what central government committed to the international community, while the cabinet decided not to reopen the Vodafone issue. And resolutions were passed at the central cabinet that India does not encourage retrospective levy of any tax or duty. There is a clear articulation because otherwise, under the bilateral investment treaty, this was considered to be indirect expropriation by a levy of a tax, which otherwise it was not authorized to levy with retrospective effect. So that's a commitment given by the central government to the international community. And here we are saying that the government would have powers to levy the electricity duty and tax on sale of electricity with retrospective effect. I think that's something which is completely incoherent with, number one, commitments given by the government of India and the international practices on the tax. Therefore, coming back to the DISCOMs and its operations and health, and what is it that the committee has been trying to say, that we need structural reforms, and we need drastic structural reforms. I think one of the areas which again Harry touched earlier today was in terms of old plants, old PPAs, and the kind of procurement price for DISCOM being very high, being unreasonably high, and being not in consonance with the market practices. If Tarini infrastructure judgment of the Supreme Court, which came in July of 2016, said that under certain circumstances, regulators can now open the PPAs and look at the procurement process, and under the overall objective of correctly determining the procurement process and the price. It gives a large area open on both sides. And I think we've had this debate in terms of sanctity of contract all through the reforms from 91 onwards, whether the PPAs have the sanctity of contract, whether in India there's sanctity of contract or not. But regulators, if they are now under certain circumstances required to or can open up the PPAs and renegotiate it commensurate with the market realities today, and if that happens very quickly, and I think that's one of the elements where I think DISCOM restructuring needs to focus on, is its procurement process and how. And I think, incidentally, state government yesterday came out with the state government's procurement policy on all goods and services. So I've not seen that, and I don't know how that will impact and affect the procurement of electricity by DISCOMs. But the issue would really be focusing on, if the procurement policies are revisited today, the delta that is there in rest of Maharashtra, with 75 paisa duty being levied currently under the 2016 Electricity Duty Act, the delta for open access today is about 2 rupees. That delta of 2 rupees can very quickly be bridged by the DISCOM by looking at its procurement processes. If that happens, and if they have today every information and every data, including the customer behavior, that is what it's trying to get through it being a nodal agency under the open access distributor. It's no longer going to be a level playing field. It's no longer going to be a promotion of willing seller and willing buyer concept coming in. It will be a coercive buyer and an imposing seller selling the electricity. Therefore, the concept of willing buyer and willing seller will give way to a coercive buy and sell. And that's how I look at it from a lawyer's perspective, to say it's death to open access. Thank you very much.